the first part of this will be Dean Benny and Darren Knight from the technical side of the AEP team, and they'll just go through section 117. So if you've got any questions, certainly just either take yourself off mute and ask, or raise your hand, and then I'll just have a little bit at the end around the assessments and just some feedback on the assessment reports. But I'll now pass it over to Dean and Darren.
Thank you, Michael. Kia ora koutou katoa, everybody. I'm Darren Knight from the Accredited Employer team. And you may notice this, I looked at these slides we've got here in the spirit of sustainability. Dean and I have recycled an extremely old PowerPoint presentation, which is from the old ACC branding, etc., etc. So enjoy the blast from the past. The information remains pretty much the same. So we're quite fortunate on that front. This is a fairly stable piece of knowledge that doesn't change dramatically hasn't changed dramatically over the years. So we're quite fortunate in that front. So yeah, we'll encourage anyone today, if you want to jump in and ask questions as we go, please feel free. It's going to be more of an overview kind of situation, because I says, well, you may, if you want to, ask the questions, but getting right into the weeds of the section possibly isn't part of what you need. But if you want to, we're very happy to do it. And if we start off with section 1171, because they're probably the two sections we're going to talk about are 1171 and 1173. And as you can read there, corporation can suspend, and that's an incredibly important word, or cancel an entitlement if it's not satisfied on the basis of information in its possession. And again, that's really important too, information in its possession, that the client's entitled to continue to receive that entitlement. So that's sort of just the broad overview. Dean, do you want to add anything to that?
Yeah, we were asked to talk about suspension, so that's the very essence of it. And as you mentioned, Darren, there is more to section 117. There's another part of it that enables decisions when somebody's non-compliant, and we're actually not going to talk about those today. They're probably a session in and of themselves. So yeah, just suspension of entitlements, as it's commonly called, which is very much a case-by-case thing. It's very much about the evidence, but there are some sort of overarching principles that we can talk to that hopefully will be of interest and of use. That's probably click, Michael.
So what does it do? As it says exactly there, it suspends or cancels an entitlement that's in place, that's no longer required as a result of the injury. So what that means is well, there's probably two things to take out of that, or three actually. One is the suspends, which I think we're going to talk about a little bit later on, which means it isn't stopped forever and a day. It's sort of held in suspended animation in case if something else can change, which can alter that, that state of being. And it's entitlements that are in place, and I think we'll talk about this later as well, but it's often you will see people attempting to sort of use this to shut the gate forever and a day on everything in the future. And that's possibly one of the things you may see on some of the files. Letters will quite often say that, it'll say we're suspending everything forever and a day, and you can't do that. And the other one is it's no longer required as a result of the injury. And what that means is they may still require it, but it's not the injury that is the reason they require it. So those are really important points just to be aware of, because it's a funny area that when you know it well, it seems, well, to us, relatively straightforward, but it's very easy for people to confuse some of these things. Dean, can you add to that? I'm sure you can add to that.
I think you've nailed that, Darren. Yeah, that there might still be a need for an entitlement. A person might still be incapacitated, but this is a section that comes into play where that need is no longer related to an injury. Yeah, as you've already said, basically that's the nutshell, and that's a click. So yeah, what we've witnessed over time is some confusion around the section or parts thereof, and potentially seeing it used in a way that is intended to shut off a claim, close it down, render entitlements never ever payable again in the foreseeable future. And that's not what the decision does. It does reflect a point in time where the evidence is clear that injury is no longer the cause of the need for a particular entitlement or a group of entitlements that are in place. Yeah, any insights on that one, Darren? It's something we've seen certainly historically as a
Yeah, and I think the in place. I think we'll keep circling back to that because that's a really important one. Is that effectively, if someone's going to suspend a case manager or somebody suspend an entitlement, they really should be able to name that entitlement. If you said, so what have you suspended? If someone couldn't really answer that, well, I've suspended everything. That's not, it should be, weekly compensation, perhaps some form of treatment or what have you. But it's they're currently receiving it, and we're suspending that. So. And I don't know whether we get onto this in later slides, but this doesn't preclude someone from coming back and reapplying for those entitlements if their circumstance has changed, and you've got to look at that, and or coming back and asking for another entitlement. So there might be something. Am I jumping ahead here, Dean? I'm not sure.
no.
Yeah, so you might find somebody comes, so you've suspended perhaps weekly compensation and some sort of rehab, but someone comes back and asks for a separate entitlement that wasn't named. You can't just go, we've done a suspension decision, so look at that. You can't have that. You've got to reinvestigate and issue a new decision. Now you'll often find that all of that rationale and all of that evidence will still apply to your new decision. So you can decline to provide that one, Dean, or what would be the wording you'd use there if someone asked for
it would be an actual primary decline decision. If something was requested,
decline,
that wasn't in play before, then that's not something that's been suspended or that you would suspend. If you've been asked for an entitlement, let's say it's home help, and that hasn't been in play before, it wasn't suspended previously, then you would decline that using the relevant sections of the Act.
Yeah, so you may use all the same rationale and the same reasoning that you did for your a suspension decision, but it's still got to be a new decision with new review rights and that sort of thing. So you will often see people will try and use the old or the previous blanket 117 to blanket everything else that comes in, and that's not the case. And also it may not require huge amounts more in terms of investigation if you're using the same evidence. But you still got to issue another decision.
Just a moment. Sorry, Darren. There's someone can put themselves on mute because we're getting a lot of background banging and crashing. Please.
Someone's doing plumbing.
Yeah.
Wrestling an alligator.
Mm-hmm.
So just put yourself on mute, please, or you. Carry on. We'll just have the sound effects.
So yeah, a person might have their entitlements suspended validly and on good evidence, and that doesn't alter the fact that they still have cover for their injury, and conceivably later they might validly come back and need entitlements again, and that can be injury related again. Perhaps a surgery comes up further down the track and that is validly related to the covered injury and gives rise to a further period of incapacity, then entitlements would turn back on in essence. So it's not a decision that prevents future entitlement. It purely deals with entitlements that are in the place at a given point in time and that are no longer required because of injury on the evidence.
You have a click, Michael. Thank you. Well, this is Dean's thing. Yeah, you go.
Fair enough. So there's a number of decisions in the courts on this topic. One of the leading ones from the High Court is Elwood, which sort of talk to the point that if you have two opinions that are opposing and of equal sort of value in terms of evidence, so they're both well-reasoned opinions. One says, yes, this man is entitled, and the other well-reasoned opinion has a great rationale for why they're not, then you're not in a place to actually suspend entitlements according to Elwood, the High Court decision. So the evidence really needs to be singing from the same song sheet, or there might be a number of opinions that say, no, this person is not entitled, and perhaps one opinion that's off in the wilderness and unreasoned with no rationale that says, oh, yes, they are. There needs to be a weight of evidence that makes it pretty clear that it's no longer an injury that is the cause of the need for entitlement, is the nutshell of the Elwood case.
And the important part there is as Dean said, it's got the sort of veracity of the evidence you're using. I had one quite recently where a TPA was recommending not suspending on the basis that they had, well, they said two, there were several opinions that were opposing. And what you had was exactly the scenario Dean said. You had several specialists saying one thing, and you had one other specialist saying another thing. And the other specialist, A, there was a weight of evidence, and B, the one that was out in the wilderness just wasn't a well-reasoned decision. So the actual weight of the decision, was very much towards suspension. So it's not just the fact you have got opposing opinions; they've got to be decent opinions as well.
Yeah, the courts have been clear that when we're talking in an ACC land, the specialists can't just rely on their magnificent qualification and tell us what the situation is. They do need to provide a rationale and to provide a reasoned opinion for it to persuade a judge, shall we say. Yeah. And that'd be a click, I reckon, Michael. Yeah, I mean, we've already touched on that, haven't we? Yeah, it's two opposing, equally valid opinions with different rationales and different ultimate decisions would not leave somebody in a place to be what the legislation calls not satisfied. So, yeah, that balanced evidence isn't enough.
And you'll sometimes see someone who's managing a claim who's quite keen on wanting to suspend, and they will almost turn a wee bit of a take a bit of a head in the sand approach. They've got this opinion which is saying you can suspend without really looking at the other weight of evidence that says you sort of can't. So, if it's hanging in the balance, you can't go, well, I want to suspend. It's just not enough. You've got to have some pretty good stuff there.
And we won't bore you with the judgely quotes there. That'll be another click there, Michael. Thank you. This chestnut used to come up all the time in case law, that because the Act talks about not covering things that are wholly and substantially due to degeneration or aging in terms of what is personal injury, but it almost has disappeared from judges' decisions and review decisions in the modern context, which is I find interesting. It's probably academic, but this whole wholly and substantially used to come up a lot, and there were percentages thrown around. But nowadays, it's all about the evidence and whether the evidence points to the cause for the need being injury related or being something else other than injury. So it's kind of disappeared off the landscape, which I found interesting. These slides, I think they're from 2013, and it was quite relevant back then, but it's just disappeared off the landscape in terms of suspension.
Yeah, it's interesting, isn't it, seeing how these things have evolved a little bit. Like I said, it's a pretty stable piece of thinking and legislation, but even in that time, you can see how some of the landscape, the flavour changes ever so slightly.
That'll be a clip,
Michael. Thank you.
So it is about causation. and what one of my favorite judges would call a causal inquiry. And it's not about a casual link to symptoms. There must be an injury that is the cause of the need, or a condition that has been caused by an accident or a covered gradual process, etc. And it is not about possibilities or tenuous suggestions, or maybe it's this, maybe it's that. It is about probability. What is likely? The balance of probabilities, as the judges would call it. And we know that aggravating underlying conditions, or even accelerating an underlying thing that already existed but was stirred up by an injury, is not causing that thing. It was already present, I think is almost verbatim what a judge said. So stirring stuff up, what already exists, does not attract cover and would not be a basis for continuing entitlement in sort of ACC land.
And I think Dean makes a good point there. You will often see specialists talk about they're not really sure what's going on, and they'll talk this possibly caused that. And sometimes I think perhaps the less experienced claims people take that as, oh well, there's a causal link there. Whereas what Dean said, we're looking for probable or likely or some, much better than possible. Yeah, it's possible. It also possibly might have been caused by a meteorite that fell out of the sky, but it's not what we're looking for here. And that's a really important thing to look for, I guess, when you're perhaps on a claim file and trying to figure out whether someone's found some decent evidence. Does it say likely or probable or something like that rather than possible? Because it's a really there's a big difference between those two things. So yeah, just because it's possible doesn't make it so. Are we clicking here?
I think so.
Oh, this is a good one. Do you want to do this or me, Dean?
Oh, I think it's probably a tag team one, but yeah, the terminology I've used there is global. And what that means is the section and suspension is not focused on an individual claim. It can involve more than one claim, and it's about covered injuries that are relevant. So Keneally there is a bit of case law that's quite a good example, and a very sort of plain example. Back in the day, Mr. Keneally, I think he had a sore back, and therefore ACC determined that his sore back was no longer due to the covered injury, the strain or similar that he'd suffered back in the day. So they suspended his entitlements. But he was actually presenting medical certificates showing that he was incapacitated due to an epicondylitis or similar on another claim. And therefore the judge overturned the suspension decision because ACC could not be satisfied that he was no longer entitled to that entitlement. The judge said he was. So it's not on a claim by claim basis. It is looking at injuries that are relevant. And if there's another injury that is, I'll say plainly, contributing to the need for entitlement, then that would not be a basis for suspension. I have seen case managers and reviewers get off into the weeds, and I think again trying to chase down possibilities, but we're not really into possibilities. It is about what's probable and is the cause of ongoing need that is relevant to a suspension decision. We also don't have to solve what one of the High Court judges described as the medical puzzle. If we can be very, very clear that the cause of the problem is no longer an injury, then we might not be able to establish exactly what is the cause of symptoms and the need for entitlement, but it is enough if we can be very, very plain that an injury is no longer playing a part, then we're still into suspension country. And I think on occasions, people can get lost in trying to chase down what the solution to the medical puzzle is, or into possibilities and every claim that's ever attracted cover for a sprained thumb or whatever in the lifetime of a person. But it is about evidence that suggests that injuries that are relevant. So we don't have to chase down every possibility. It is about the weight of evidence and injuries that are relevant and giving rise to need. Anything else there, Darren?
Yeah, I would say possibly one you might see on file, and we see it a lot these days. Fortunately, it seems that the TPAs and the AEs have cottoned on to this idea that if you want to suspend, you need to be, if there's another injury floating in the background that could be a need, could be the reason for a need for entitlement, you can't suspend. And so they'll often look to transfer sort of the provision of entitlements across to another claim on the basis that they can't suspend on theirs. There's a couple of issues there that sometimes it's clear that they just don't really feel like suspending and going through the whole sort of negative decision, go to review. So we're going to try really hard to sort of find an ACC claim to put it on, which is probably not the best thing. Or at times there will be other claims possibly floating in the background. As Dean said, it's not a possible. So what they'll often do is come to ACC and see, is there any other claims sort of floating in the background that we sort of perhaps we've heard some talk in a report that perhaps there might be another claim, and ACC can sometimes take up to 7,000 years to figure that out when it comes across. And when Dean says relevant means that claims attracting entitlement. It doesn't have to be a similar. So if you've got a knee claim, you're not looking for necessarily other knee claims. It can be any other claim that could be attracting entitlement. So yeah, that might be something you'll see on file quite a lot, is this look to perhaps transfer the entitlements across, or asking ACC to look into it. So yeah, so it's about sort of having a reasonable suspicion, I guess, that there is another claim. So as Dean said, it's not possibilities to, if someone, for example, has a back claim from 1992 that required 2 physiotherapy treatments, you don't, the likelihood that that's the one that will be attracting entitlement is pretty small. So yeah, it's got to be a sort of a relatively probable thing that another claim is likely to be attracting those entitlements. Otherwise, you can suspend. So yeah, it's not just they've got other claims, so that surely we can have to look at all of them. You don't have to. Have I missed anything there, Dean?
No, I mean, looking at those words, if I was writing that today, I wouldn't use the terminology believe. I would say that if the evidence indicates that there's a covered injury that is the cause of another covered injury, shall we say, rather than the claim you've been focused on, that is giving rise to the need for entitlement now. That would be the sort of terminology I'd use nearly, well, it's probably 10 years later, but.
And it's interesting how that has changed, that transfer of entitlement issue is a in some ways it's good, because we've managed to impart to the TPAs and the AEs that is a global decision, so you can't suspend in isolation necessarily, but equally it has brought up that issue of transfers of entitlements, which makes things a little tricky on some occasions. Can we have a click, please, Michael? Oh, that's probably what Dean said earlier, that a suspension is just that, a suspension. So you haven't shut that door forever and a day. People could come back if the evidence changes or the situation changes. You can reinstate effectively an entitlement if the evidence supports that it's an injury-related need.
Spot
Anything
on.
to add to that, Dean?
No, yeah, I think we've covered that off. We really have in the past seen it utilized like something that shuts down a claim forever and a day, and it doesn't have that effect. The only thing that would do that is if cover entire was revoked on a good basis. But yeah, suspension decision reflects the evidence at a given point in time, and that scenario could change over time. Yeah.
But certainly if someone came and reapplied for that same entitlement and nothing had changed, there's no need, and obviously you'd look at it, there would be no need necessarily to issue a new decision with new review rights. You just effectively just let them know that the old decision, the previous decision, remains in place. That would be correct,
So
wouldn't it, Dean?
And
Yeah,
that
so
is
it's
not a new decision in and of itself.
yeah.
Yeah, there's a real balancing act, another seesaw, but this one's really about whether there's genuinely new evidence that you would need to consider and actually provide a fresh decision on. And often it's the same evidence regurgitated on a different letterhead. So it would only be if there was genuinely new information that a person could require a fresh decision on the entitlement, the suspension. That will be a clip. I like the little people.
Well, this is an issue. I'll let Dean jump in, but probably the first thing that you often see is people will mix up the Section 103, which is the incapacity part of the Act, with Section 117. So it's really important that people make sure they are using the same one. And yeah, it's just the fact that people cross-pollinate that quite a lot. And yeah, Dean will add some more interesting stuff to that.
Yeah. What we've seen is people going down the suspension track, and there's a few good decisions on the topic, and they've actually lost track of what they covered in the first instance. So one of the principles in looking to suspend would be to look back at what you actually covered and then take the judge's causal inquiry into whether that is still the causative thing, the thing that gives rise to the need for entitlement. So one example is ACC suspends entitlements because the person's ongoing issue is low back pain, not an injury at all. But they neglected to look at the fact that that's actually what they gave cover for in the very first instance. So they couldn't suspend entitlements because the issue now is low back pain, which is not an injury, because they actually covered that in the very first instance. So, yeah, that's always sort of a first principle. What do we cover in the first place? And sometimes we get lost and forget about that. And also, yes, Darren's already touched on this, but if a person is fit to return to work, then that's not a suspension decision. That's Section 103, which is about incapacity. So an incapacity decision would be made if somebody's fit to go back, whereas it would be a suspension. And something that we'll touch on momentarily, I think, is that a suspension is a little bit gentler. And when somebody's no longer incapacitated, they effectively lose their entitlement immediately. But if they're incapacitated, but it's no longer because of the injury, we're required to give notice. So there's a bit of a cushion there. When they're still not fit for work, it's just the fact that it's no longer an injury that is the ongoing cause of that fact. Yeah. We've also touched on the fact that it's not something that on an initial request is used, Section 117. That would be whatever legislation applies to say, no, we're not going to start that entitlement for you. Whereas suspension is you're receiving this and now you're no longer entitled to that due to the fact that it's not an injury that's the cause. So we'll have to say goodbye and part ways.
And where this may be another slide, I'm not sure. Can you click forward? I'm sorry, Michael. Let's just check. No, this may be another one. But in terms of
it's coming up.
the time frame.
Yeah.
The notice. Oh, okay, right. Well, I'll just keep my powder dry on that one then. Yeah. Michael, can you give us a click, please? And this is what we touched on earlier when we were just simply talking about the quality of the evidence. You know, what are the facts you've got, which specialists are using. You'll see something, for example, somebody might be pitching an occupational physician opinion against an orthopedic opinion, and there'll be two issues to perhaps take into account there. One, if it's a purely orthopedic problem or question you're asking, probably the orthopedic opinion would hold some weight over an physician opinion. And one of the things we see, and partly it's an expedience thing because the physicians are easier to get hold of and get opinions from, is people will seek an physician opinion. The danger of that, of course, if it's, as I said, if it's a purely orthopedic or other specialist area, you may find yourself trumped by another opinion by the relevant specialist. That said, occupational physicians often give far better reasoned opinions than some of the other specialists. So you might be in a situation where you're pitching specialty against specialty, but perhaps the quality of the evidence given by one of them might be better. So as Dean said, there's a lot of juggling here, which is really important. And the rest of that was from another slide about how to get information. So we probably don't need to talk about that anymore, do we, Dean?
No, I mean, we have seen specialists veer into advocacy, and sometimes that works in our favor because they're not providing good, solid rationales. They're just arguing for the person to get an entitlement or continue to receive an entitlement, whereas on the other side, there might be a well-reasoned opinion based on radiology, etc., and that can mean that opinion doesn't have the same weight or value compared to the well-reasoned stuff. As you've already touched on, Darren, reviewers in particular will often sort of weigh evidence in quite a rudimentary way, and based on the speciality, like if it's an orthopedic matter, then it's good to have an orthopedic opinion. They'll also sometimes favour an opinion because of examination, and that's not always relevant. We do see, for example, ACC's clinical advisory panel that just looks at the history and the notes and the radiology, MRIs, etc., and will provide very reasoned opinions. We'll see judges favour that where it's well reasoned, and it's highlighted that the fact that they haven't seen the person doesn't really add value or subtract from the value, if you like. So sometimes we would suggest to people when they're getting opinions that they ask the specialist if they need to see the person or whether that they can rely on the information that's already been gathered around the traps to provide an opinion.
Clicky, please, Michael. Here we are. Here's the notice situation. So the Act requires that someone's given reasonable notice, and reasonable notice is obviously how long's a piece of string kind of wording. So you may find in ACC's policies it says there's 2 weeks if it's been under a year, and 4 weeks if someone's been receiving that entitlement for over a year, and that's obviously to give people time to get their affairs in order and figure how they'll manage post a suspension. But with an AE, they are not bound by ACC's policy-driven timeframes there. So, reasonable, they can make any call that they feel is reasonable. And quite often with the AEs, actually, they're surprisingly generous, which is great. But that's important, that there is, unlike a Section 103 decision where if today you have a medical certificate and all the evidence says you are just not incapacitated any longer, i.e., you can go back to work now. Your weekly comp can cease now, whereas with a suspension decision, there has to be a little buffer built into that to soften it slightly, as Dean said, which is what we see. Dean, can you add anything to that?
No, you've nailed it. Like you say, I anecdotally on occasions, perhaps where the incapacity's been extended, accredited employers will give more notice than the bare minimum. But by the same token, I have seen confused decisions that have stopped entitlements immediately, and reviewers will sometimes completely overturn that decision from what I've seen, but others will tinker with it and revise it so that there is a notice period and the effective date that the decision will have effect when the person will lose their entitlements. So not worth an accredited employer failing to give notice and then leaving it open to the reviewer to completely turn them over.
And rock and roll, Michael. What does this even mean?
Right. So having made that decision, an accredited employer, should they be have their decision contested at review or even further on in front of a judge in the district court, the way things have evolved is there's kind of a double jeopardy or a two-tiered approach to that decision. It's worth knowing about. So the first hurdle is the reviewer or judge will look at the evidence and determine whether, when at the time they made the decision, whether the accredited employer and potentially their third-party administrator had enough evidence to clearly be not satisfied that entitlement existed any longer. And then if that hurdle is successfully jumped, then the reviewer or judge will then look at any further evidence that's come in and whether the decision is still sustainable in light of any additional evidence that's come in. So if they determine that the evidence was imbalanced when the decision was made, it couldn't really be called, then they'll fail. They fall at the first hurdle and the decision will be overturned. If they make the first hurdle and there's a whole lot of evidence that's come in later that says, no, this is actually due to injury, then they'll fail at the second hurdle. So there's really a two-tiered approach to these decisions when they're being reviewed or appealed. Do you reckon that made any sense, Darren?
No, not at all. Yes, it did make perfect sense.
Well, it was worth a crack, Nige. It's one of the fundamental principles that would come into play as it sort of goes on to review or appeal. And like as we've said, this really does come down to a case-by-case basis and a weighing of the evidence in an individual case. So it's very hard to talk other than at a generic level about cases of this nature. You've got to weigh the evidence when making a decision or when it goes to review. But there are some fundamental principles like the fact that there will be a two-tiered approach if you do go to review, that it is global, and it doesn't shut off a claim forever and a day, those sorts of things.
We click through, Michael. Oh, there we are. So hopefully that has, it's a very high level overview of suspensions. As Dean said, they're always very, very case specific because you're trying to weigh evidence and decide, the veracity of the evidence and whether you can make those decisions or whether there are other claims in play and whether more evidence comes in later, which because it's a suspension, you may revisit that decision. Any number of things come into it. So they're quite complex in terms of the swirl of information, but in lots of ways they can often be, once you're familiar with how this all works, they sort of make sense to us, at least, Dean. So yeah, do we have any?
Sometimes.
Sometimes, yes, and but I don't know what you'll be seeing on file, so I'd be interested to know if anybody has any questions around what you might see in your course of your days. Does anybody have any questions? Or have we just confused the living daylights out of everybody?
My rationale is either we've covered it off beautifully or everyone's asleep. So,
yes. Or completely confused. Can we go back to the start? Because I'd be interested to know whether that is something you see sort of pop up on files and what issues you might see with them. Because it's certainly one that people can get wrong.
I think it's probably one of the tougher decisions to make right on a claim. It does require, some real ability to consider the evidence and weigh all the opinions that might exist on a claim and discern what the common thread is and whether it's sufficiently common that you're in a place where you can suspend. If anyone's interested, we could certainly do a session on the other aspect that's in 117, that non-compliance and decline to provide decisions under subsection 3, where somebody's being a bit naughty maybe and their entitlements will be withheld until they play ball. There's, again, quite some nuance to that.
Okay, well, thanks, Dean and Darren. If there's no questions on that, I'm going to throw them both under the bus and throw it open that if anyone's got any other perhaps technical question that they may not answer right now, but we'll get back to you. So, sorry guys.
No, it's quite all right, Michael.
Both.
I would like to point out that if you throw me under a bus, that is a work accident. So
not motor vehicle.
Is this on the weekend in your own leisure time?
That's another workshop. That one's coming up.
No.
But if no one's got any questions, I can let Dean and Darren go, and then I'll just do the little bit that I wanted to cover off. Okay.
That's cool.
Got away lightly, gents.
Thanks, guys.
Yes, nice.
I hope that was of some value and made a little bit of sense.
But we're as Michael with his bus throwing has just said, we're open to be contacted at any time, and yeah, we'd like to hear from you if you need us.
Okay, cheers. We can hang on if you want, or no. Darren's gone. I'd say Dean will be going soon.
Have a great day.
Cheers. So I haven't got a lot to get through. Hopefully we can get this through before 10 o'clock and you're now back in your day. I just thought I'd go over how the assessments have gone so far, because it's 6 months in, and then it's just some feedback on the assessment report writing. So there's been a few more assessments have come in since I put this information together, but from 1 April to 30 September, there was 79 reports received. And of those 79, unfortunately, 19 accredited employers did not meet requirements. So they all ended up with an action plan. I haven't given this information to the AEs or TPAs. It'll go out in the next newsletter. So I'll just ask you your discretion with this, because they won't be happy that you're getting information before them. So if you could just keep it under your hat for a couple of weeks. Of the 79, like I said, 19 have not met. Interestingly, 14 of those were previously at the tertiary level, and there was some fear that those AEs that were at the primary and secondary would struggle, but 14 of 19 were previously tertiary, and just 2 were secondary and 3 were primary. And to break it down a little bit more, of those 19, 10 of them had requirements in safety management and injury management they didn't meet. So they, for want of a better term, didn't meet both parts of the assessment tool. 10 were safety management only. So 10 were in safety management only. 7 were in injury management and safety management. And then there was a couple that were injury management only. And ironically, one of those was an AE that's ISO certified. So they only could fail on injury management. So that's the basics of what's happened. I thought I'd also let you know what some of the frequent misses were, but I won't go through all of them. But again, that contractor PCBU area is an area where people have been struggling. Also, the other area is just going to get the thing. So yeah, records showing monitoring of PCBUs. So 9 of the 19 didn't meet that. Another area where people have struggled with is records showing that they're reviewing their compliance with legal and health and safety requirements. That's 7 times that's occurred. The one that did always come up in the old audit tool was emergency evacuations. There was not as many, but 4 times. And the area that other people have struggled with is having management having their positions reviewed against their health and safety responsibilities, and that's come up 4 times, but there's a smattering of other ones around there. So they might be areas you just want to have a look at. Just the report writing. So we still are using exception reporting as the rule, unless it's a new accredited employer coming in, then we want a full report. So you can simply say for a requirement, if nothing's wrong with it, that you're not making a recommendation. You simply say no issues or documentation cited to meet requirement. Obviously, those assessment areas where they're not met, we do require the detail of what was not met, and I'll say that again in a wee while. And then also you've got to make a recommendation linking back to that not met, and I'll just state that again in a couple minutes. And also those requirements that are met with flexibility, just a rationale, they've started to roll out training for management, but they've got a plan to roll it out continuously, so it's met with flexibility, and then you can make a recommendation along the lines of make sure that you continue that plan, that you're rolling out that training. The thing that we have as myself and the monitoring specialist is obviously we're not at the assessment, so we don't know what's been said or what's been presented, and sometimes we'll be coming back to you to clarify things. So if you are going to be putting detail against those assessment requirements, just clarity. So any ambiguity, we'll be coming back and asking a question. So one area that has cropped up a couple of times is combining the training. So there is training in the claims and injury management area, which is assessment area 2, and then there's training in the health and safety part of the assessment tool, which is assessment area 10. Occasionally we're getting comments that it sounds like, for example, in assessment area 10, there's information about claims and injury management training, but that should have been in assessment area 2. So we just come back and ask those questions. So because we're not there and we don't know, and it's just making sure there's clarity, no ambiguity. For the accredited employers that are ISO certified, we still need the information about their health and safety. So it's just informing us about their health and safety system. Yes, they're ISO certified, you made that statement, but do they run a paper system, an online system? The online system's only available to some people. And just information about health and safety overall for the AE and for the assessment area the assessment site that you're at. So, if it's at a manufacturing site, this information about the specific hazards there as opposed to the head office, which we have different hazards. So it just gives us information. It's information the monitoring specialists use in their recommendations. So just providing that detail. Like I said about the critical issues, it's about the evidence was what was not there. So I've got 2 examples. The first one in assessment area 1 is where rehabilitation plans. So this is one area that has failed or not been met. So 4 of the 6 rehabilitation plans did not show any consultation between the case manager, injured employee, and the team leader, supervisor, or whatever. So that's why it's not met. And then you make a recommendation, ensure that your processes include consultation with the appropriate people when developing the rehabilitation plan. The other one, the reviewing of PCBUs and other contractors. Again, so they still got 8 contractors, but they've been doing no performance monitoring or reviewing, so there's no evidence of that. And again, the recommendation is making sure that they do that. Some more general ones about the report writing, the recommendations, keep making them. They're really good, and there are a number that are coming through. We're keeping a bit of a tally on the most frequent ones, and I'll talk about that another time. But there are some that are coming up quite often. There's some assessment requirements that are coming up with a recommendation 10, 15, 20 times. So it's obviously an area that needs to be looked at by the AEs. Assessment area 1, requirement 149, which is about the referral letters. So initially we said to the AEs and TPAs that if you're making a referral to a provider, a specialist, that you need to provide that referral letter to the injured employee. Through some negotiation with the AEs and TPAs, we said, okay, perhaps you don't have to send the actual referral letter, but what you do need to send in lieu of that, in place of that, is a letter that clearly states or clearly explains the purpose of the referral, a clear explanation of the potential outcome of the referral, and what information was sent to that external provider. So ACC 45, med certs, any return to work plans, GP notes, physio notes, and also just a note in the claim file notes why the actual referral letter wasn't sent and why this, for want of a better term, abridged letter was sent, which, like I said, explanation of purpose of the referral, explanation of the potential outcome, and a list of the information. We do see occasionally that there's a mention, a reference to an appointment letter, and an appointment letter to me is, Michael, you're going to Dr. Smith at this address at this time. And so again, that's that wee bit of that ambiguity, just being really clear about what was sent. Another thing is in assessment area 12, the overlapping duties. The comments that are being made are being all very specific to the contractors that they're engaging, that they're bringing on site to do work for them, whether it's a builder, plumber, electrician, or whatever. But also, there's not as much comment about those overlapping duties to those people that they don't have that contractual arrangement with, the people they're sharing the workspace with, whether it's Kmart in a shopping mall, whether it's a port and they've got other people working there, whether it's a freezing works or some other manufacturing site where they may have ammonia and they've got neighbours and they're not telling them about the potential issues if anything happens. So if you're making comment about the overlapping duties, just also consider those other ones. It's not just that contractor one, but also those neighbours that they may have an impact on because of what they're doing. And in assessment area 16, the workplace observation, this is an area where we do need information. And a lot of the comments in one area, which is 16.4.4, which is around the first aid equipment, are saying, there's first aid stations, they're stocked, they're reviewed. But this requirement also includes any fleet vehicles. So if there are fleet vehicles, making sure that, perhaps there's none there at the site that you're at, but if there is, just having a check on them, making sure that if they've identified first aid equipment for fleet vehicles, that they do actually provide it in those fleet vehicles, and making a comment on that. So those are just a few areas I just wanted to cover off. I'm happy to take any questions on any of that, or if you've got any other questions, or Dean and Darren did say that, they could look at the other part of suspension, which is suspension when someone is not doing what they should be. They're not turning up to appointments, so they might look at that. So we can have that as another technical topic down the track. But John, you got your hand up.
Yes, Michael, I got asked a question recently about deemed decisions on rehabilitation plans. A rehabilitation plan is sent to the claimant and they are expected to sign it and return it, or however that works. If they don't sign it, there's a process to have it deemed after a certain number of days. The question is, what constitutes agreement to the rehabilitation plan? Is it that need to be signed on the rehabilitation plan? Is an email saying it's accepted, or a text saying it's accepted, or a verbal phone call that says, yes, I agree with it? At what point is that not sufficient evidence and it would require the plan to be deemed?
Yeah, so the assessment tool talks about the individual rehabilitation plans specific to injured employee are developed in direct consultation, and then individual rehabilitation plans are reviewed and updated by agreed timeframes. So we don't actually have the signed bit in the assessment tool, and it's similar to the old audit tool, and it's sort of surprised me it's never come up before. But in regards to what would be acceptable evidence for the plan being accepted by the injured employee, they could have a return email saying, yeah, I agree with that. If there's clear documentation in the claim file notes that it was discussed, not just IRP and then the next thing, but some, and not chapter and verse, but some bullet points, discussed the IRP with Michael, discussed these 4 things, these 3 things. There was verbal agreement, sending him the IRP, or, for want of a better term, signing or agreement to. There's that, but I see Sarah's just jumped on, so I'll let you.
I'll just jump in. Thanks, Michael. John, yeah, the agreement doesn't need to be a signature. Obviously, a signature is the easiest and most obvious way to show that agreement, but a text, as you've said, Michael, a text or an email confirming that they are in agreement with what the content of that plan, that's fine in terms of agreement. But the other bit that I wanted to jump in here with is we're seeing deeming of rehab plans as a method to show a plan as agreed. So we're getting rehab plans, we're seeing this in monitoring. A rehab plan will be developed, not obviously in consultation, but it will be developed, it will be sent out to the person by email, and along with that plan there will be a predictive statement saying, if this is not agreed in 1 week, it will be deemed. That is not how deeming works. So you can't just say, I'm sending it, if it's not back by then, it's deemed. If you are going to finalise a plan in that way, there needs to be really strong evidence on the claim file that you can see that there have been efforts, not just sending it out and waiting to hear back, but there have been efforts to gain agreement. So in our monitoring, we're trying to put that message across that deeming of plans is not a tool that you use in every instance to say this plan's going to be agreed. So I don't know if you're seeing it on the files that you're looking at, but it's something that we need to steer or try and steer people away from. It's certainly there as a tool for when it's needed, but it should not be a predictive, this is how we're going to get a plan agreed tool.
Yeah, no, that's good. Thank you.
And I might be crystal balling here or reading something into the question, but hopefully they are older claims where they were going to meet the primary requirement of 21 days or the secondary requirement of 14 days. Now they've got 28 days, so they've got more time to, as Sarah said, make sure there is that consultation, that engagement with the injured employee to discuss and get agreement to the plan. So hopefully future ones are.
So just me again. So yeah, absolutely. There's that scope for that agreement. It also gives them scope to go back so you've got that conversation, that consultation, that development, that happening, hopefully, but there needs to be, that gives them quite a bit of space to go back and say, look, I haven't heard from you. Is there a problem with this plan? So I know I'm hammering the point home, but we do need to see really proactive efforts to get a plan agreed after that hopeful initial consultation. That's me.
I'll just jump in, actually. It's Michelle here. Just also because, of course, the performance targets now have the IRP in there. So I guess it sometimes reflects in having been left a little bit late of that 28 days, or actually if that's the target, sorry, I can't remember top of my head if it's the same, but I've seen that personally, yes, where it's left it sort of that last week to meet it, so quickly send it out. If you don't get it back in a week, it's deemed to just reach that target. So yeah, thank you.
Thanks, Michelle and Sarah. Any other questions, or people might want to get on with their week? Okay, well, I'll call it a day. Thanks for everyone that's turned up. I did get a few late minute people saying they weren't able to because of things cropped up, but this is recorded, so it'll be sent out, and the things I talked about will also be on the PowerPoint. I just didn't want you to keep staring at a PowerPoint, so you got to unfortunately look at me. So that's all, but thank you all, and hope the rest of your week goes well.
Thanks, everyone. Yeah.